Hi viewers, in this video, I'm going to explain about the one of the important topics which comes under business. You know, you already know about what is called business law, and also you know there is an act called Indian Contract Act, which is talking about the rules and regulation of entering into an agreement between the two parties regarding the any kind of a trade practice or commercial activities. In that contract act, right, there is a one important topic called classification of contract. You know, right? Whenever you are entering into a contract into an agreement, right, with the two or more parties regarding the trade or commercial activity, you know there is an act called Indian Contract Act. But under that, there are various types of contract act has been enacted by the Indian Contract Act. Under that, there are three categories of classifying your Indian Contract Act. The one is the first category is according to enforceability. What do you mean by enforceability? That means your contract, when you're entering into a contract with the people, whether the contract has been enacted as per the rules and regulation. That means you know there are 10 major elements are there for getting into a contract where you need to have a two parties and it should obey the rules and regulation and there should not the capacity of the parties should be fulfilled, right? And the contract should not be in a started right through the coercion, right? It should be a the people should accept both the parties should accept the entry into the contract. So like that, there are various elements are there. When all these elements are fulfilled as per the section 10 of Indian Contract Act, the particular contract is called as a valid contract. Valid contract. The second category of a contract as per the law is called a void agreement. That means if particular agreement, for example, sir, I want to enter a contract with the person B, right? So for that, first the offer should be given, and that particular offer should be accepted. This particular offer has been made by creating a document called an agreement. When this agreement is not as per the rules and regulation, if there is any mistake or if there is anything, any important points that has not been mentioned as per Indian Contract Act, so if it is not enforceable by law, the particular document agreement is called as a void agreement as per section 2G of Indian contract. This is the second one. The third contract comes under, according to enforceability, is void contract. That means, as per section 2I of Indian Contract Act, if any contract, if any contract is going to be seized, that means stopped as per the enforceable law, right? And it is called as a void contract. So, for example, see, a person, right, he promised that he will marry the person B, but later person B has died. In this, the contract has become void because of what the incident happened. So that means, as per the rule, the both are entering into an agreement contract, but one of the parties are not, no more, right? It forced them to close the contract. That is called void contract. It is called void contract. Fourth important contract under enforceability is voidable contract. That means if two parties are entering into a contract by making the agreement as per the law, but after that it is noted that some of the one of the parties, right, has been made this contract right in an illegal way, or by threatening the other person, or by using some loopholes right in the rules and regulation, and he made it. And finally, only you realize that that particular contract is not a valid contract. So it is called as a voidable contract. That means a contract may become avoidable in the future because after knowing a certain things, once your contract is made, it is called voidable contract. So these are the important types of contract coming under the enforceability. And the next one is coming under, according to enforceability, illegal agreement. Right? If any person is making an agreement, that is a document illegally. What do you mean by the illegal agreement here in this, as per the Indian Contract Act? They are telling that if it is forbidden by law, if your agreement is forbidden by law or the object that you are considering in the agreement is forbidden by law, that means it is not recommended by the rules and regulation of the Indian contractor. But you are mentioning that if that is there, that's become an illegal agreement. Second one is right. If you are permitted, it would defeat provision of law. That means you are violating the rules and regulation of the rules Indian Contract Act, or any kind of fraud activities, or any kind of a forgery activities. If you're mentioning in an agreement and you're like making of duplication or damaging all this thing, that also comes under illegal agreement. And as per the section 23, a court is regarding that this is immoral. That means the activity that you are engaging or the agreement that you have made between you is an immoral, means against the law, means then it is considered as an illegal agreement. Then the next one is, as per the according to enforceability, is unenforceable contracts. That means a contract which is not enforced as per the court of law. Because when you are making an agreement as per the rules and regulations of the Indian contractor, you made the agreement, offer is given, accepted. There are two parties are there, and all the rules and regulations you have fulfilled. But there are certain formalities has not been completed. Maybe you may not filed that particular contract. It has not been signed properly, or it has not been sealed properly, or in certain columns, right, certain things has to be clear. So in such cases, if the contract right becomes in this way, then it is considered as an unenforceable contract. It is considered as an unenforceable contract, right? These are the contract which is classified according to enforceable. That means as per the law. Now there is a second category called how what are the different types of contracts according to formation. That means in what way you are going to follow to create the contract. What way you are going to follow to create the contract. Under that we have a different criteria, different contracts are there. The first one is express contract. So section 9 of Indian Contract Act says that any proposal, any proposal or offer of the person who is going to give the other person, if it is made express in terms of words, express in terms of words, it is called as an express contract. Express contract. It's the same thing when the proposal or the offer is made by the party A, the party B, apart from the words, right? Apart from the words, it is called implied contract. So this is talking about how you are going to make it. This depends upon the what type of contract you are going to enter, whether it's related to some kind of a business or trade or personal thing. Based on that, you can say that whether it is express or implied contract. Then the third one is called quasi contract. So the quasi contract is a one kind of a special kind of a contract, right? Where you're not involved or you're not engaged as per the right with the mandatory regulations, right? It is talking about even though right there is no contract between you and the other party, there is no contract exists, but you're in the situations or the event what has happened, right? It made us to follow what it is. Right. The best example, what I can say about quasi contract is, for example, when you are getting into a bus, right? If you want to travel from one place to another place, when you are getting into a bus, automatically as a passenger, you are supposed to take a ticket, right? And it is mandatory for the ticket collectors also to issue the tickets by getting the money. Now, there is no agreement between you and the ticket collector. There is no agreement between passengers and the ticket collector, but you are meant to follow that particular regulation as per the act. Like it can be a transport act or it can be any kind of a rules and regulation of our constitution. It mandatory says that even though you are not entering into the contract, but once you get into the bus, right, it is you have to consider that you have to take a ticket for your fare charge, and then you have to pay money and you have to get the ticket and you have to travel with that particular ticket. So this is called as a quasi contract. That's why it's mentioned that which are not in truth contractual in the sense of vesting of agreement, but the law treats as if they were, even though there is no contract between you and in the ticket collector. But you need to be considered that you have to take a ticket as you are traveling in the bus as per the Transportation Act or whatever it is. This is called quasi contract. So the third one is according to performance. Now we already discussed about as per the law what are the different types of contracts are there and how you are making the contract. Based on the mode of creation, you have different types of contract. Now, how you are going to perform your contract. That means how you are going to execute your contract into an action. There are different types of contracts are there according to performance. One is executed contract. Executed contracts. This means when both the parties who was involved in this contract, right, has completely performed their part. That means, sir, from my part, I performed everything. From your part also, you have performed it. That means I also fulfill all the criteria, all the conditions. They are also fulfill all the criteria and condition, which talks about executed contracts, right? Executory contract means a contract is ready, the agreement is ready, but it yet to happen. It yet to happen, right? Once particular event has started or the particular incident has started, right? It's like arranging a, like having an agreement or having a mutual acceptance between both the parties, right? And engaging the activities that are for upcoming event, upcoming programs, right? We need this, so you are giving and on based on this, it is yet to happen. It is yet to happen in the futures based on the requirements given by the both the parties. It is called executory contract. Third one is called unilateral contract. Unilateral contract, right? Where from the one of the parties it has been happened, right? So whatever from my side, I had completed my part, and the opponent part has to start his work or he has to perform. For example, see, sir, he has lost his son, and he said that if those are persons who is finding my son will be rewarded this much rupees. So he has given a commitment from my side. I had given an offer, and it has been published, it has been advertised. My part is over. Now, rest of the thing is, if anybody else, right, finding his son, right, once it has happened, once he's got him, once he's handed over to EA, right, and now he has to pay 50,000 to the particular person. So one party has fulfilled, the other party is yet to perform, right, or going to perform. That is all unilateral contract. Uni means one. Bilateral contract is where both the parties are right into the contract, and at the during the time of formation of the contract, they are ready to perform. They are ready to execute. It is like a similar to the executive contract. They are ready with everything. Everything is ready. All the agreements are made, and all the agreements are sanctioned by the government officials, and then other things, and it has been ready to perform. It's all called as a bilateral contract where both the parties are ready to perform. Right? This is about the bilateral contract. Right. So hope you understood the different types of contracts in this video. Right. With this, we will see the another important part of business law in the next video. Thank you.